The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. 3 cases will be submitted this morning. Those cases are TBS Holding and 911 North Governor versus Board of Adjustment for the City of Iowa City, consolidated with TSB Holdings 911 North Governor versus City of Iowa City. The second case is Valerie Banstra and others versus Covenant Reformed Church. And the final case is State of Iowa versus Michael Sheffert. Sheffert matter was now submitted to the court without an oral argument, and will proceed to hear the arguments in TSB Holdings. Mr. Meardon.
Thank you, Your Honor. May it please the court. Counsel, my name is Chuck Meardon, and I represent TSB Holdings. In the limited time we have, I am going to try to highlight 5 things in 5 years of litigation in 2 cases. And you may have to rein me in at times, but as a little outline, what I'm going to try to do is first talk about the elephant in the room, which is Dakota. But even if TSB gets beyond Dakota, there are issues in the construction of the remand order and of Kempf that led 2 other courts to conclude that TSB nevertheless was not entitled to relief. Those matters relate to the personal nature of Kempf, or at least 2 courts believing that Kempf was personal to the original Kempf plaintiffs, and the ability to build did not extend to owners of the property. There are issues with respect to the remand order as highlighted in the concurrence. The concurrence essentially saying it was illegal. There are issues with respect to what was the proximate cause of the harm to TSB. Was it the zoning ordinance upon which the Board of Adjustment relied to deny TSB's site plan, or was it the Board of Adjustment's refusal to apply Kempf? And then finally, there are issues reached by the district court with respect to construction of the terms of the decree related to owners or owners and their successors and assigns, developed or established uses, that the Court of Appeals declined to reach because of its conclusion that Dakota was outcome dispositive. So with that in mind, and with the time permitted, I guess we'll start with Dakota. So TSB reads Dakota to be a statute of limitations case. The Court of Appeals read Dakota to be something more based on, and if I may quote the language, focusing on the words near the end of the ruling, the 20-year period commenced, and speaking of the 1977 judgment at issue in Dakota, the 20-year period commenced when the judgment was entered. Because the 1977 judgment were not renewed, it expired in 1997. So the Court of Appeals is of the opinion that that didn't affect a remedy, it affected a right.
And actually, that's my opinion too, and what I want to hear from you, because I understand there's a little bit of a groundswell out there among real estate practitioners, is whether Dakota was rightly decided, and if not, why not?
I'm not trying to duck your question, Your Honor. I think the issue in my mind is what did you mean by Dakota? The only argument that wasn't made in the Dakota case that I would raise with you now is the accrual and when does your cause of action accrue. You've made the policy decision with respect to injunctions and the like that, that certainly is a reasonable decision. But again, I think Dakota, I can't say it was wrongly decided by this court, but what I can say is I believe the Court of Appeals didn't interpret the case as was intended. Again, it's pretty significant that Dakota is a statute of limitations case. And in the statute of limitations, and this is in the brief and in the concurrence, when the court wants to limit the viability of rulings, I'm sorry, not the court, when the legislature wants to limit the viability of rulings, it knows how to do so. It said so in 614.17, quiet title actions, 615.1, which says certain judgments after 2 years are void. So I guess our issue is not so much with how Dakota was decided, it's how Dakota was interpreted by the Court of Appeals. I don't know if I've answered your
So
question.
you haven't answered it the way I want, but you've answered it. Your interpretation of Dakota is that it doesn't set kind of an expiration date for judgments, notwithstanding that language that you quoted to us. But what it does is say, if there's a violation of a judgment, you have 20 years from the violation to sue. Is that what you're saying?
Yeah, basically, when does your cause of action accrue? And again, the accrual issue wasn't addressed in Dakota. It's, and generally speaking, Your Honor, a statute of limitations affects a remedy and not a right. And that's the Albrecht case, 648 Northwest 2nd, 87. So what the Court of Appeals essentially read Dakota to mean, or B, is that 614.16 was more like a statute of repose than a statute of limitations. So assuming that Dakota is a statute of limitations case, then that gets us into the issue of whether the trial court abused its discretion in allowing the Board of Adjustment to.
Let me follow up some more with this underlying issue about Dakota. So if it's a money judgment, let's say it's a money judgment, not a more complicated injunction like we have in this case, then wouldn't that accrue as soon as the judgment's entered? Because the money's owed as soon as the judgment's entered, right?
Yes, no doubt. And following on your lines, Your Honor, if it was the intent of this court to say any cause of action on a judgment accrues upon rendering, okay. We just need clarification on that issue, and that's the horror stories by the bar. But let's assume that that's true. In that sense, that's not outcome dispositive of TSB's issues. If, again, your cause of action accrues, that doesn't mean it isn't an affirmative defense that still needs to be pled and proved, and that did not happen in, the statute of limitations was not mentioned in the zoning case, 15-1573, and when the Board of Adjustment attempted to raise it, the district court denied that motion. So, again, it's very significant that the statute of limitations affects a remedy and not a right. Now, I don't know. I guess that's up for this body to decide. Did Dakota intend to extinguish a right? I don't know. But I think that's one of the reasons we're here.
So when did it accrue in your case?
In our opinion, it accrued when the city rezoned the property in 2013. And, Your Honor, I think it's important to note that from when the Kempf ruling was entered until 2013, every party to this litigation, well, this involving the city, not the Board of Adjustment, it wouldn't have been involved, but under city zoning, they still believed the property was zoned R3B. The comprehensive plan in 2008 talked about R3B zoning. And dovetailing into another argument that's going to be coming, which is the personal nature of Kempf, in our judgment, it is relevant that every party to the decree originally from the remand order on believed that the ability to build apartments on that property was not solely held by Kempf. Otherwise, why would they keep the old zoning? And you have the testimony from the zoning administrator, Julie Tallman, who, and I know I digress, but I'm trying to loop around to this personal issue at the same time. But we say it accrues in 2013 at the rezoning.
And should we apply Dakota only prospectively? Was it that type of a change in the law that should not be given retroactive application?
Well, you know, that's a really interesting question. And I guess that depends on whether you view Dakota as a statute of repose or a statute of limitations, because in this, if I remember right, and now don't hold me to this, of course, I think it's the Albrecht case or another case, they're talking about if it's a statute of repose, and it runs, in this case, 20 years from when the judgment was entered, that would mean that any right was extinguished as of 2007 before the rezoning. If that's the law and it's a statute of repose, there was no right lost by TSB in the first place because it disappeared as of 2007. So in theory, it's not a retroactive application of anything. But again, in the Albrecht case, I think it is, and don't hold me to that. And that's briefed our view in terms of the retroactive application.
The motion to amend, add the statute of limitations defense, keep that issue alive for purposes of this appeal?
I would say the Board of Adjustment timely raised that as an issue on appeal. The motion to amend was denied by the trial court for the reasons set forth in its ruling. So I think it's certainly, if you're asking me jurisdictionally, has it been preserved for appeal? Yes, no doubt. Can you pass on it now? I think, well, I mean, you can do anything you want, but from the trial court standpoint, when it was considering the motion to amend, not only was it the at issue, it was latches and a number of other affirmative defenses that would have required proof beyond how the pleadings were framed at that time. And in terms of applying the statute of limitations now, yeah, I guess you could pass on whether that was appropriate, but TSB would have been denied the chance to argue an equitable estoppel of the application of the statute of limitations, which I think was, one of the reasons it was denied. Again, raising the statute of limitations that late in the game, near the close of discovery, as I recall, opened up a whole panoply of issues that now, if this court decides to pass on the appropriateness of the denial of the motion to amend, TSB may be denied the opportunity to make that argument. Now, I'm not saying it's the greatest argument, but the opportunity would have been denied.
Let me shift gears. All right, let's say we decide that your client is not untimely in its effort to enforce this 1987 remand order. There's this other language in the order that says, once a use has been developed or established on any of the above described properties, further development or redevelopment of that property shall be subject to the zoning ordinances in effect. Now, as I understand essentially what your client wants to do, there is an old DHS building, an office building, and parking for that building, and those would be removed and replaced by an access road and parking and 3 24-unit apartment complexes. Now, why isn't that barred by this language that says further development or redevelopment of the property? Why isn't that further development or redevelopment of the property?
Looking at the remand order, the remand order applies to 4 specific parts of the property. And remember, this is assembled lots. You have 49, 50, 51, 8, 9, and 10. The DHS building you are talking about is on lots 8 and 9 and is not addressed by the remand order. The lots where the apartments are going to go are those protected under the remand order, lot 49, lot 51, and lot 10. So those lots are in essentially the exact same condition they were back when Kemp was originally decided.
But you're using lots 8 and 9 for the parking.
Perhaps, certainly for access, and that's true, but again, unless that is inconsistent with the underlying zoning, I think that's acceptable.
Was parking allowed as a auxiliary use under residential?
Yes, parking is in fact required for a residential.
Talking about the rezoning, is it allowed as an auxiliary use? Not as a primary use, but an auxiliary use?
If I'm understanding your question right, I'm not trying to duck it. I guess what I'm saying to you is that any development has a parking requirement under city ordinances.
Yeah, but can you use 8 and 9 for parking under its present zoning?
I believe so.
And you think the ordinance does that? Is it an auxiliary use then? Because the primary use is low-density residential.
The primary use of lots 8 and 9, yeah, it has R1 zoning, if that's what you're saying. Well,
Can you put parking for a apartment building on lots 8 and 9?
if lots, I believe so, but let's assume that I'm just completely wrong about that. That doesn't mean that there can't be parking for the Kempf contemplated uses on part of lots 10, 49, and 51. And to your point, TSB has never contended that it knows exactly what it can and can't do under Kempf. It asks those questions, and that may be an issue that comes up. The court may say, okay, you know what, you can't do this on lots 8 and 9 because that's subject to the new zoning. We don't know. We asked those questions. We wanted the city to review TSB's site plan under Kempf, but it declined to do so. So I can't tell you exactly what is or is not permitted under the existing zoning on lots 8 and 9. We've asked, we weren't told. I see my time is up. Is there anything else? And I guess we can take that up on the rebuttal, but thank you.
Thank you as well, Counsel. Ms. Craig?
Good morning. May it please the court, counsel. My name is Liz Craig. I'm here with Sarah Greenwood-Hectone. We represent the Iowa City Board of Adjustment and the City of Iowa City in this action. As Mr. Meardon indicated, his client's claims have now been considered under many different legal rubrics. As a zoning case, the BOA and the district court held a trial applying the Kempf orders. The Court of Appeals applied the statute of limitations under 614.16. It's the city and the BOA's position that there are many potential grounds for affirmance in this case. Today, I'd like to focus my argument on some of the issues raised by the Court of Appeals in its consolidated decision, especially concerning its application of Dakota and some of its consternation in doing so. Next, I'd like to talk about the pleading issue. The Court of Appeals did reverse and remand TSB's taking issue for further proceedings, and the city filed an application for further review on that ground as well.
Let me ask a question. Where was the statute of limitations preserved at the district court?
The BOA raised the issue of statute of limitations in a motion to amend.
And the district court denied it.
That's correct.
So was it ever litigated at the district court?
Well, the city provided the district court the opportunity to pass on that issue.
But was it litigated at the district court?
It wasn't decided at the district court. I would not concede that it wasn't litigated at the district
How
court
does it get
level.
preserved? You know, if I file a lawsuit and the district court says that's not an issue in the case, and I'm not letting you in, isn't the appeal issue that you should have been allowed to amend it rather than the merits of the issue?
And that was an issue on appeal. And that is that the BOA argued that issue to the Court of Appeals that we should have been.
It seems the Court of Appeals, on its own motion, entered an order to brief the statute of limitations when it wasn't raised or decided below.
It wasn't
It wasn't decided below.
It wasn't decided below.
How does that preserve it for appeal? How does that preserve the statute of limitations issue on appeal?
Because the BOA did raise the issue below and it was urged on appeal.
Well, what's your argument that that was an abuse of discretion to deny the motion to amend?
The BOA's argument as to being an abuse of discretion was the fact that the motion to amend to add the statute of limitations defense, which would have been a purely legal defense at that point, was filed 2.5 months after TSB's motion to amend its petition had been granted, was filed before the pleadings deadline had closed, before the deposition deadline had closed, before the discovery deadline had closed, and before the dispositive motion deadline had closed.
Wasn't it 5 days before the discovery deadline closed?
It was before written discovery was closed. However, depositions still could have been taken, and no discovery was ever requested, and there was never any extension for discovery.
The big picture is if the Court of Appeals is right on Dakota, if you're right on Dakota, it's just a purely legal issue, right? There's not really a factual development that needs to be done, is there?
That's correct, and that was always our position, was that this is a purely legal analysis because the clock starts ticking at the entry of judgment. We don't need to go through an analysis about accrual. It's the city and the BOA's opinion that if you look at Dakota and if you look at Chapter 614, that 614.16 makes sense as a statute of repose. And that is the language that is reflected by the Dakota decision. When it talks about expiration of rights, the duration of a judgment, that's statute of repose language. And in this case, when you apply this as a statute of repose, it makes a lot more sense as well. Because if TSB's argument is that its cause of action accrued in 2013, it has until the year 2033 to bring an action on a rezoning that occurred in 2013 based on a 1987 judgment. And not only that, but applying zoning that is from 1977. Now, that is exactly the kind of situation that a statute of limitations and a statute of repose is meant to prevent entering into the courts.
And I get that argument, but I mean, as someone who represents the city generally, aren't you a little bit troubled by the notion that any equitable order that might be in effect, that might be lurking somewhere, might benefit the city of Iowa City that's out there, is automatically expired after 20 years if it hasn't been renewed? I'm guessing your office hasn't been running around renewing various property rights that it might have by way of court decree at the 20-year point in the past, has it?
Not that I'm aware of, Justice Mansfield, but you know, if an injunction order is important enough to a party that it needs to extend past 20 years to preserve those rights, I expect that party is going to take that action. And that's something that potentially could have been done by Wayne Kempf in this case if he had actually intended to pursue any further development rights for that property. The order was granted in 1987. Mr. Kempf then did in fact build one more apartment building. Then he granted an easement to Mid-American Energy across the buildable land. And then he stopped building. And then he sold off the property in pieces. And Mr. Barkalow from TSB Holdings eventually reassembled the properties into one tract.
Doesn't the language kind of protect you? I mean, or at least give you an argument, because you can say that language I quoted to Mr. Meardon, that it's already been developed and therefore any new development is subject to the new ordinances that are now in place. I mean, you still have the argument that the injunction wasn't meant to last forever, but if it was meant to last forever, it strikes me as troubling that it just ends after 20 years if you don't run in and renew it. Mm-hmm. Am I right?
I think that that is the way that Dakota needs to be read given the language of this court. And that was what the Court of Appeals held. There are a lot of bases, as I indicated, for affirmance for the city and the BOA in this case. I think that the statute of limitations is one of them, and that it makes sense to apply this injunction in this case because of the time period that's gone by, the change in parties, the change in uses around this. There was testimony at trial about how the traffic patterns here, police needs, fire protection, things like that are impacted. But to focus on your question, I think it cuts both ways, is ultimately how the court's holding in Dakota has to be read. And in this case...
Does it seem odd to interpret the statute interpreted in Dakota as a statute of repose when it's in a provision governing limitations, and we've got other code provisions that govern stale uses and provide expressly for certain interests to expire after 21 years. So how should we read those together?
There is the Stale Uses Act that states that certain uses expire after 21 years. I actually think that is support for the application of the statute in this case. Statutes of repose coexist with statute of limitations in Chapter 614. This court made a distinction between them in the case law, and so it's the legislature's decision, of course, what a statute of repose is, but I think that the language in this case does not make it unusual that this would be a statute of repose within Chapter 614.1.
What about this redevelopment issue? Lots 10, 49, and 51 were never developed. I mean, they're just bare ground. So how can you say that those were redeveloped?
Well, there's the DHS building and the DHS parking building.
That building's not a subject to the Kemp order, because those lots weren't subject to the Kemp order.
That's
and
right.
that's a different issue, whether or not, you know, you could use it as parking, and you never answered the question for them, and I don't know what the answer is, if it's a primary or auxiliary use under the zoning laws.
Right. And so part of the problem with breaking up those lots for development in that manner is that the site plans that we've received from plaintiffs have always included the entire tract. They are not limiting development, and practically it would be very difficult to limit development to just any of those three tracts.
But you could have told them you can't tear down the building. Now, they could leave it vacant and use the parking that used to be for that building maybe, or use it as a driveway, but you never told them that. I mean, they never got that response from you because you just denied it outright. And I just want to know how lots 10, 49, and 51, which were never developed, how that's redevelopment.
Well, if you have to tear down a building and you have to tear up a parking lot in order to put in your other buildings.
But that's not subject to the Kemp order. The Kemp order prohibited redevelopment. Lots 8 and 9 were not under the Kemp order.
Mm-hmm. But they are necessarily included in the entire tract, and as those uses are developed, they're going to be implicated.
But if you denied their site plan and say you're not allowed to use that property, they could have submitted a little smaller apartment building where there's less parking and would not have to tear down 8 or 9. But you never got that far. And that's how the development process works. It's a give and take. But you had no give.
It's a give and take if they had the rights that Kemp had. But that's the underlying presumption that's false. TSB did not have Kemp's development rights, and that's always been the city's position and the BOA's position.
Let's assume they did. Okay, let's assume they were successors or assigns. We may disagree about that, but let's assume they did. Why couldn't they build, does the further redevelopment, development or redevelopment preclude them on lots 10, 49, and 51 when they were never developed in the first time?
It does, because at that point, you're going to have to be developing pursuant to 1977 zoning, which is going to make it impossible to comply with current zoning on the other lots. You can't box those portions of that property in without necessarily including the others.
But that hasn't been shown yet. I mean, that never was passed on by the city. I don't know that to be true. I don't know if the city would allow them to use the driveway to get in if they granted an easement over that parking lot.
Well, and the city never received a site plan that would have allowed it to make that determination even. There's only been a site plan including the entire lot, the entire tract here, which extends the scope of Kemp much further than the Supreme Court held in 1987. I will briefly pass, unless there's any more issues about the Dakota matter, on the issue of the takings claim in this case, which is the city's application for further of review. It's the city's position that TSB failed to meet notice pleading requirements in making a takings claim. The takings claim comes up within the city action. There were 2 petitions filed in that case, one for a declaratory judgment and for a temporary injunction before the zoning went into effect, and one for certiorari after the zoning actually occurred. And it's within that cert petition that there are the words unconstitutional taking. However, there is no mention whatsoever of damages, and the only relief prayed for in that petition was to void the zoning. Subsequently to that, the case was litigated for a number of years, and there was no litigation of a takings claim whatsoever. In fact, TSB filed a motion for summary judgment and did not include anything about its taking. It was not a partial motion for summary judgment. It never designated any experts. It never took any discovery whatsoever throughout the course of litigation. And so it was the city's position at the district court that that claim failed as failing to meet sufficient notice pleading standards. The Court of Appeals held that based on some language that did not actually appear in TSB's petition, that they had in fact made a damage claim in that case. And that was an error in the record by the Court of Appeals. It's the only fact actually cited within the Court of Appeals' opinion regarding the takings claim and the claim for damages. And it's a very important fact because without that claim for damage, there's a mere mention of an unconstitutional taking that was never litigated. And certainly if the city had perceived a taking claim, it would have proceeded very differently throughout litigation with much more significant discovery. The case potentially could have been removed out of the Iowa courts completely at that point. And it's the city's position that given the way that the pleadings actually were framed and the error by the Court of Appeals in the record, that there was not sufficient pleading of that issue, and the city requests that this court reverse on that matter.
Thank you, Ms. Craig.
Thank you.
Mr. Meardon, you may present your rebuttal.
Thank you, Your Honor. I want to go, I don't know if I adequately answered this issue about what you can do on lots 8 and 9, but I think, Your Honor, you've put your finger on the frustration that TSB has had all along. It wouldn't have mattered what plan TSB submitted given the zoning administrator's opinion of the zoning. That was the whole basis for the denial of the site plan. And in fact, if you go back in the briefing, TSB has made the point, yeah, we would like to know what we can and can't do under Kempf because we understand that lots 8 and 9 and the south 186 feet of lot 50 are not subject to the remand order. But nobody would ever tell TSB the answer to that question.
Could you address the city's argument from a moment ago that the takings claim should not be regarded as part of this case going forward? And specifically respond to the city's argument that it is prejudice because it would have conducted the litigation differently and done discovery into that issue had it been properly pleaded.
Yeah, well, at the risk of sounding somewhat obstreperous, I'm not sure it wasn't adequately pleaded. And before I forget, in terms of what the city was or was not told, there is a letter you will find in the Board of Adjustment Appendix, page 252, from an appraiser who talks about the damages by virtue of the down zoning. But be that as it may, to adequately answer that question, you would have to go back to when I first got involved in this case back in 2014, if memory serves. The city asked that the pleadings deadline be extended, and this occurred, I think, maybe 60 days before trial. So all of this, there was still time in terms of litigating a takings claim. So the pleadings deadline was extended so parties could file cross motions for summary judgment. And, you know, if TSB's motion for summary judgment had been granted, then the takings claim would have been completely moot because then they could have gone forward and built. And if you read the transcript of the hearings, I mean, we have said all along, yes, TSB has a takings claim, but the issue is, was the city put on sufficient notice of the possibility of a claim? I mean, a takings claim usually involves damages. And again, you have that letter from the appraiser. So again, I think it's hard.
On a different pleading matter, how would TSB have been prejudiced if the court had allowed the amendment to plead the statute of limitations? What would you have done differently?
Well, we would have raised, again, not saying it's the best defense, but you have the equitable estoppel defense in terms of defeating.
Could you flesh that out?
Well, it's basically like for lack of a better term, a party makes statements upon which the other party relies, knowing they are false. And again, what is so important as far as that goes is, until 2013, everybody, everybody in town would have been, according to the city, would have been able to build apartments on that property, which again, you've been cited the authority, which in our mind is germane in determining what the Kempf Court originally meant. The party's conduct for 20 years after Kempf was decided indicated that apartments could be built on that property by anyone. In the last 50 seconds that I have, I need to talk about a couple of other things with your permission. The Court of Appeals decided to declare the remand order in this case illegal as being completely contrary to the intent of the original Kempf decision. This is in the briefing. I think the remedy, if that remand order was illegal, which TSB does not believe it was an authorized extension, the remedy is not a collateral attack on that decree 28 years later. It's either a cert action or an appeal of that order 30 days after it's entered. And I would think that the fact that the city attorney himself blessed the language of the remand order is a pretty good indication that at least every party to that original Kempf litigation thought that the right to build applied to anyone who owned those separate lots and not just Kempf himself. So, once again, I'm out of time. I don't know if there are any more questions. I'll take it from the reaction. The answer is no. Thank you for your time.
Mr. Meardon, thank you as well. The case of TSB Holdings is now submitted to the court, and we'll next hear the arguments in Banstra.